creditors' claims against an estate, and paying deceased bills before probate. That's our topic today. Let's get started. Loved ones can pass away owing a variety of unpaid debts. Probate acts as a legal clearinghouse for a decedent's unsecured creditors' claims against an estate, demanding payment of a monetary liability or debts after death owed them by the decedent. Many probate executors and administrators choose to begin the process of paying deceased bills before probate in California. In California, creditor claims are required to be filed regardless of whether the liability was due, accrued, contingent, or reduced to a cash value when the decedent died under Probate Code Section 9000. Hi, I'm KimWard. I'm a certified probate real estate advisor here in San Diego, California. If you find this of value, hit that like button, subscribe, and hit the bell button so you're notified of my weekly videos. So let's continue. Generally, most creditor claims must be filed in the probate court proceeding within 1 year of a decedent's death under Section 366.3 of the California Code of Civil Procedure. If necessary, a creditor may even commence a probate to file a timely creditor's claims against an estate. The personal representative, the executor or administrator of a decedent's estate, is required to mail a notice of probate and creditor claims form to all reasonably ascertainable creditors. Also, petitioners seeking to commence a San Diego probate are required to publish a legal notice in a local newspaper of general circulation here in San Diego County to put potential creditors on notice. My experience is here in San Diego that your attorney, your probate attorney, would post in the paper for you announcing the probate. They do this before we put the home on the market in most cases. What I do to help with this process is I request our title company to provide lien information. That way we aren't surprised if we have some types of liens on the property before we put it on the market. And it can take a few weeks to get that type of information from the title company. Once a creditor knows that a probate has commenced, the creditor should notify the decedent's personal representative and request a notice of probate and creditor claims. The personal representative has 30 days from knowing of a creditor to provide the creditor a notice and creditor claims form. I recently helped a client from Canada, and her father had passed away here in San Diego, had a home in the Claremont area of San Diego, and she wasn't surprised when I pulled the lien information with the title company because she had known that her father had some kind of a lien on the property by the city of San Diego. So we pulled that information and we started going down what we needed to do to figure out if that lien was still in force. As it turns out, the lien expired in 2015, but was never removed from the property. And the really good news is that Karen, my client, wasn't charged what would have been charged to pay off that lien to the city of San Diego. So you can see how it's really important for your real estate agent to pull the information from the title company way before you even put the house on the market. In California, creditors must use the Judicial Council Form DE-172 Creditor Claims Form. The completed claim form must be filed with the court overseeing the probate proceeding and be mailed to the personal representative, the executor or administrator, and his or her probate attorney. The filed creditor claims must also be timely and complete. Timely means the claim is filed either within 4 months after probate commences or once the letters of administration are issued, or within 60 days of when the notice of the probate was given to the creditor, whichever is later. Creditor claims must be supported by a sworn statement of the creditor or his or her representative, like a debt collection company under the Probate Code Section 9151. First, if the claim is due when filed, the statement must state that the amount is justly due, that no payments have been made that are not credited, and that there are no offsets. Second, creditor claims that are not yet due, where they haven't matured or have a contingent claim, including pending lawsuits against the decedent's estate, must be supported by an affidavit showing the facts supporting the claim. Supporting documentation can be provided. The DE 172 form has instructions. Creditors who complete their own creditor claims forms must do so very carefully. An incomplete or inadequate creditor claims form invites rejection by the personal representative. If a creditor claims is partially or entirely rejected, the rejection typically starts a 90-day period for the creditor to file a timely lawsuit to dispute the rejection of the debts after death. Only demands for monetary compensation require a creditor claims. Thus, claims that do not demand money, such as a demand for specific property, do not require a creditor claim. This is not intended as legal advice. Please consult an attorney for guidance. Thank you for watching. I hope you found this of value. Please remember to put comments down below, like this video, hit that bell button, and subscribe to the channel. Thanks again.